Good afternoon, everyone. Good morning. We're delighted to have everyone join us today for this webinar. We are delighted as the Center for the Study of Law and Religion at Emory to host this conversation. And we thank you for your participation. As many of you may already know, the Center for the Study of Law and Religion at Emory is now over 40 years old. It's an interdisciplinary academic center that studies the many intersections of law and religion. That work takes many forms, including research and scholarship, teaching and training, as well as public programs. And so we're delighted to host this conversation this morning. And I will turn it over to my colleague, Dr. John Bernal, our Director of Digital Scholarship, who will introduce our moderator. And then we will get on with the program for the day. As you may have seen in the chat, please use the Q&A feature to submit your questions. We look forward to a robust Q&A session with the panelists and moderator at the conclusion of their formal remarks. So thank you again for joining us, and I'll turn it over to John.
Thanks, Whitney. My name is John Bernal, the Director of Digital Scholarship here at the Center, and I want to welcome all of our audience members and panelists, and also our distinguished host, Pamela Slotte Russo. I first met Pamela in her capacity as a McDonald Distinguished Senior Fellow here at the Center, but this is only one of the many roles that Pamela occupies in the Academy. She is also the Professor of Religion at Law at Abo Academy University in Finland. She is the affiliated Senior Research Fellow at the Eric Castren Institute of International Law and Human Rights. Pamela is the Vice Director of the Center of Excellence in Law, Identity, and the European Narratives at the University of Helsinki, Finland. And lastly, she's also a member of the Finnish Academy of Sciences and Letters. Pamela recently edited a special issue on the end of law in Studio Theologica, the Nordic Journal of Theology, which came out in May of this year. And we're grateful to share this time with Pamela and her distinguished colleagues. So Pamela, thank you.
Thank you so much for those kind words, John, and also welcome everyone on my behalf to this webinar. And let me also start by extending a heartfelt thank you to Whitney Bart and John Bernard and all the other lovely colleagues at Emory for their supporting, facilitating this event on the nature and end of law. As John said just now, a webinar that will feature interventions from the contributors to the recent open access special issue of Studio Theologica that was dedicated to a multi-perspective exploration of the nature and end of law, both in terms of law's goals, purposes, its limits, and indeed its ultimate horizon and possible cessation. And in focus in our issues stands law in a broad sense. The articles include a discussion of law and its nature and its ends from a theological, philosophical, and juridical perspectives. It looks at positive law and divine law, biblical law and ecclesiastical law, secular law, temporal law, and floor law. Each category, of course, by no means hermeneutically sealed, but naturally displaying great internal variety. And even unlawful law is addressed, with the aim being to explore ways in which to establish and tackle such unlawfulness. And of course, such a many-sided take on the nature and end of law calls for the engagement of a broad spectrum of scholarly expertise. And that said, I just want to shortly introduce the scholars, Nordic colleagues of mine, with whom I've had the great pleasure to collaborate in my capacity as guest editor of this special issue. But one of the authors, Professor James Svenningsson, was able to be with us today to join this conversation, and we are really, really grateful for that almost everyone was able to make it. And in no particular order, I will start by introducing Matilda Arvidsson, Senior Lecturer of Jurisprudence at the University of Gothenburg, Senior Lecturer in Legal History at the Technical University of Luleå in Sweden, and currently also an affiliated visiting scholar both at the University of Lund in Sweden, and Turku University in Finland. And among other things, she researches jurisprudence, international law, legal aspects of AI, as well as colonial legal history and its contemporary iterations. Morten Björk, in turn, is a researcher at Lund University and a lecturer in systematic theology at the Newman Institute in Uppsala. His interests are primarily in political theology and the relationship between metaphysics, ethics, and theology. Tormod Johansson is senior lecturer and docent in public law at the University of Gothenburg, and his research spans both traditional fields of public law, such as administrative and constitutional law, including the law of crisis and war, but also interdisciplinary work in political theology. And together, Tormod and Morten have just finished a monograph on Gustav Radbuch, H.L.A. Hart, and Ernst Wolfgang Böckenförde on the nature of law that will be out early next year. So keep a lookout for that volume. And then last but not least, Simon Larsson is a researcher of social anthropology and currently working at the University of Uppsala. And his research has a broad empirical focus while relating to a theoretical interest in governance and power in historical and contemporary societies. So we have a great group of scholars bringing together a broad range of talents and expertise. And after their presentations, we will have, as Whitney said, a time for a general discussion. And I hope you'll all be inspired to contribute through questions and comments to the discussion of the theme. And with that said, I would like to give the word over to our first speaker, Tormod. Please go ahead.
Thank you so much, and thank you to the center and to for this opportunity to present our work. I will just share my screen here. I have a few slides. So for a few minutes, I want to tell you something about the article that I contributed to the issue. And it's, as the title says here, about concepts of justice beyond sum cuique. And I will go through a range of different concepts of justice, which is not aimed at being exhaustive, but the main aim of it is to try to broaden our horizon, but even perhaps more egotistically, my own horizon as a jurist, as a legal scholar, because one of my things I've struggled with is that, of course, jurists, lawyers are supposed to be engaged with justice in different ways. It's sort of one of the defining features of law, the discipline of law, whether it's in practical sense or in an academic scholarly sense. But my impression is that there's a sort of restriction when it comes to the conceptions of justice among jurists, and that's what I wanted to somewhat address through this paper or article. So one of the most traditional ways of understanding justice is based on old sources. So from the Justinian Codex, for example, we have this expression that justice is the constant and perpetual will to render to each his due, which in turn is based on Roman law and formulations from Ulpian, where we have this sentence of sum cuique, which is about rendering each his due, or giving each one his or her due. So this is one of the basic ways of describing what justice is, and it's very influential even today, and a sort of basic assumption in many descriptions of what justice is. And I will also come back to the fact that this is a sort of basic structure of the legal or juridical way of understanding what justice is. But of course, there are a much broader range, as many of you listening in will know, in how you can conceptualize and understand justice. A famous example is, of course, from Aristotle, justice as a virtue, which of course has a deep history and is also a continually discussed throughout the history of Western culture. And I won't go into any detail here. I just want to note that while Aristotle defines justice as a virtue, he also says that there is a certain subset of justice as a virtue, which he calls partial or particular justice, which is about distribution and sharing and how to handle transactions. But this is only a subset, which I will also return to. This in turn is connected to a very common widespread account, and I would say the most important account of justice today, which is justice as fairness. Justice as fairness or equivalence. And there are many different descriptions we can use, or many accounts we can use for this, like ranging from Rawls to Dworkin to Hart and etc., many authors. But I've just chosen a quote here from Agnes Heller, which I engage with in the article, the philosopher Agnes Heller, who talks about the formal concept of justice, which for her is about this consistent and continuous application of certain norms or rules to the members of a social cluster, as she says. So everyone should be treated equally inside of this group. One short note on that is, of course, that just because something is fair or equal in this sense doesn't mean that it's necessarily good. You can be equally bad to all your children, which doesn't mean that you treat them well. And this has also been formulated as this concept of justice being empty, because it doesn't really say anything about what is good. We might return to that. Another concept I engage with then closer to the legal field is what the scholar Günther Teubner has called juridical justice in a very interesting article, where he argues that juridical justice today is in a sort of crisis, depending on the fact that we no longer have a firm basis on which we can put these demands for justice on. We have many different norms we no longer have a stable natural law or stable sovereignty. We have a sort of plural situation, fragmented situation of normativity. But at the same time, he points out that juridical justice always produces this demand for justice, even if it cannot supply it, and even in many cases, in a sense, destroys the possibility for justice. It's a recurrent demand both inside and outside of legal processes, which never goes away and therefore creates a sort of need to resolve this problem again and again. So what I've said so far is still inside a quite, I would say, mainstream understanding, at least from my perspective where I'm standing, a mainstream account of what justice is and how it can be understood. And now I want to expand the scope somewhat, which is why it's very pertinent that we have done this written these articles in the Studio Theologica and in this field of law and religion, which the Institute is, the Center for at Emory is engaged with and has been for such a long time. So the next example is, again, I want to turn to is from Agnes Heller, who discusses in her very interesting book Beyond Justice, firstly the idea that she calls the prophetic idea of justice. And what's important here for her is that righteousness is another term, another concept, which for her is very central and even more important in a sense historically or in a sort of deep intellectual history. And their righteousness encompasses formal justice, as she calls it, while righteousness is the more important part in a sense. And here she refers and has a long discussion about the righteous man, which is the person who is able to do what is just, which is a quite different way of understanding what justice is compared to the formal justice or the justice of fairness or equivalence. And this, of course, also goes into a theological and religious understanding of what justice is. And she quotes, and I quote here from the Bible, that God, of course, is the God of justice, but he's also the God of mercy. And this conflict between mercy and justice, which we often see in a more everyday sense, is maybe not resolved, but it has to in some way be resolved in this religious and theological understanding. And here I'm out on very thin ice, but I'm in good company, so we can expand on this later. She also talks about a more secular version of a similar idea, which she calls the philosophical idea of justice. And here she connects this directly, the example of Socrates with the example of Jesus Christ, which is, of course, that Socrates chose to suffer injustice. He chose to be condemned as a criminal and not go into exile or flee. He chose to suffer this injustice that was being made to him without committing any injustice himself by being cowardly and fleeing, for example. And Heller has these interesting formulations of him observing philosophical reason beyond reason. And for her, this is a very important idea about justice. That it's not really about creating justice in that sense, but it's rather about accepting or suffering the injustice that is being made to you. And that is a higher form of justice. And now, all too quickly, I will go on to my last example, my last reference here to sum up, which is the work of Paul Tillich, the theologian Paul Tillich, who in an interesting book has written on what he calls the ontological concept of justice. So Tillich argues that there is a sort of another type of justice which is based on the fact that everything that exists, everything that has an existence, a being, has an ontological claim for justice, that it has a claim on continuing in being. And for him, this is in conflict what he calls tributive justice, which is basically the same as justice in a formal sense, the formal concept of justice, or justice as equivalence, that these are always in conflict, because it always creates conflicts between these different claims to justice. And he has a third concept which he uses, which he calls the creative justice, which for him is the possibilities that exist for these conflicting understandings of justice or claims to justice to be solved through different forms of actions. And to put it all too briefly, for him, one example of that is, of course, God, or the kingdom of God. That is sort of this promise of the universal fulfillment through Christ or through God, is a sort of justice which is created through love. That we are promised a reuniting in a sort of unity, which is then not only beyond justice, but it's sort of justice in itself, in a different form. So to very quickly recapitulate, we have these different, and this is not, again, exhaustive, but we have these very different ideas about justice from different fields. And the question then, of course, is, to sum up, is what does this really have to do with our, at least for me, my everyday practice as a lawyer, my everyday practice in law? And I would argue that, which I do at the end of the article, that this has everything to do with everyday and current events, in the fact that beyond this partial and particular justice, which we have many calls for, we have to defend ourselves, or we have to punish the wrongdoings of peoples or states, etc. They have to be balanced by other things. For example, the forgiving of debt, the creation of equity, transitional justice, or even more everyday mediation in family law. No families are helped by exacting strict formal justice. That doesn't help anyone who is fighting over the custody of their child. And I think we can, and I hope to do in the future, develop this even more, that there is a sort of deep connection between these much more broad conceptions of justice. So thank you all very much for your attention. I will stop there.
Thank you very much, Tormod. Then I will immediately give the floor over to Morten.
My name is Morten Björk, and I'm a systematic theologian working at Lund University and the Newman Institute. And my article for this essay is called The End and Purpose of Law, Hans Barion and Gustav Radbruch on Spiritual and Temporal Authority. And the essay is a conceptualization of law and religion, and therefore the nature or end of temporal and spiritual authority at the end of the Weimar Republic and the beginning of the Third Reich. And I look at two competing visions of law and religion, one defended by a Catholic pro-Nazi apologist, Hans Barion, and another by the much more famous Minister of Justice and legal philosopher Gustav Radbruch. I could mention that Carl Schmitt dedicated his last book to Hans Barion, so he's not only a peculiar character, he's quite important in the history of ideas. And I examine how they conceptualize religious authority and temporal law during the emergence of what Barion, with Carl Schmitt and Ernst Forsthoff, described as the total state. The most important articles I look at are written around 1932 and 33, but I also scrutinize Barion's criticism of the Second Vatican Council and Radbruch's work on religion as a critique of law from the 1910s and onwards, I think this is perhaps the most novel, or whatever I should call it, perspective in my article, because I haven't seen so much work on Radbruch as a thinker of religion. He has a very peculiar and fascinating interest in religion as a critique of law as such. And I think this comparison between these two figures is of historical interest. I think it can show how leading intellectuals at the time used legal and religious arguments to defend, or for that matter, criticize the Nazi revolution at the end of the Weimar Republic. But I also think that this debate, or these positions, these competing visions of law, they still have a contemporary relevance, unfortunately, perhaps, because they are a debate over first principles. So there is a debate between, or not between, but there are two competing visions of law defended by Barion and Radbruch. That is a debate on first principles on law. And I think that debate has contemporary relevance, not because we live in a new Weimar period, but since our own tumultuous time produce debates again over first principles, such as the nature or end of law, or for that matter, the meaning and role of religion. So radical times produce discussions over the essentials. And I think we need a discussion of what Hart called the concept of law, since we are witnessing a crisis of the rules-based international order. And this is Gustav Radbruch. So he is, of course, as you surely know, a legal philosopher, a socialist politician, and he was the Minister of Justice during the early period of the Weimar Republic. And in his famous legal philosophy, his Rechtsphilosophie, from the version from 1932, he writes that all great political changes were prepared or accompanied by legal philosophy. In the beginning, there was legal philosophy. At the end, there was revolution. But the reverse is also true, namely that legal philosophies are produced by tumultuous or even revolutionary times. Radbruch is, of course, most famous for the so-called Radbruch formula, which was a debate over the first principles of law produced by the Nazi tyranny. And his famous definition is to seek three forms, or what he also called values, that define law: legal certainty, purposiveness or expediency, and justice. And he defines these three concepts as values in the Neo-Kantian tradition. And there's, of course, a big debate here if this Radbruch formula was a turn to natural law and so on. But what is important is that Radbruch, from the beginning, saw law as a mechanism of evaluation and judgment. So legal philosophy is a cultural science about the values that determine specific historical periods and specific cultural contexts. So values are the way we understand the world, and they are related to different social forms and cultural contexts. So law is a mechanism of evaluation, just like every other cultural artifact, according to Radbruch. And it's a mechanism of evaluation in the sense that it seeks to define what is licit or illicit, right or wrong, good and bad. And it also seeks to quantify, of course, different activities. It seeks to define how long a prison sentence should be, or whatever. So law is a mechanism of evaluation, both in a qualitative sense by defining what is good or what is bad, or in a quantitative sense by arguing that a specific crime, for instance, might lead to a long or a short prison sentence. But evaluation, according to Radbruch, involves conflicts and strife, because we seldom agree with the values that shape society. And it also entails, according to Radbruch, a form of Socratic relativism. At least that's for him the most mature and, in a sense, sane perspective on legal philosophy, namely that we have to accept that our conceptions of law and hence of values are relative, not in the sense that they might not be true, but in the sense that we seldom agree with each other fully. So law is produced by the relativity of culture and by the social heterogeneity of the heterogeneity of the social world. And he wanted to transform the penal code to what he called the Besserungs- und Bewahrungsrecht, the law of rehabilitation and custody. So he really wanted to make the law to something that protected the dignity of the individual, even the dignity of the criminal. And because law is bound to evaluation and thus to the living subject, who even under unfree conditions can ask, is this just? Law cannot conceptually be reduced to mere sanction or bureaucratic procedure. Law remains law precisely because it raises the problem of justice. But the fascinating thing is that his focus on religion is an attempt to move beyond the notion of justice, namely to enter the domain of mercy or grace, Gnade in German, or charis in Greek. So already in 1915, in an article bearing the programmatic title Juristen böse Christen, so jurist bad Christians, he writes that love and mercy by definition reject the demand for justice. They imply an affirmation of the human dignity of others regardless of their worth. And this is important for Radbruch, because it is only if we are ready to move beyond evaluation, because justice is always related to equity, according to Radbruch. It is only if we are ready to move beyond evaluation and, in a sense, suspend value thinking, namely suspend our need to define and to judge, that it's only if we can do that, that society can work. Because this is, according to Radbruch, not a mystical or an abnormal state. In everyday life, we constantly suspend judgment or simply refuse to evaluate. We forgive a friend who has done something bad against us and so on. Of course, we need law, but according to Radbruch, law only works if we can see that there exists something that, according to him, is much more important than law. And that was his position even as a Minister of Justice. And what is more important is this capacity to move beyond value thinking and move beyond our human need of judgment. And this is, of course, he takes this from the Christian tradition, but it also takes this from Nietzsche. He's very eclectic. So Radbruch saw legal philosophy as a product of conflicts and argued that it transfers the struggle of political parties into the realm of the spirit, just as political conflicts represent a grandiose legal philosophical discussion. So the point of law is that it's always related to different conflicts around evaluation, because the law is always related to an attempt to define what is just, and that question cannot be solved fully or absolutely. It always remains as an open question. And law, if it should be rational, should protect the individual's right to ask that question in a way that it's, of course, doesn't produce social turmoil and so on, but the individuals should still have the right to ask the question of what is just. And this is, of course, the opposite of Hans Barion's position, who was a Catholic priest and canonist. He joined the Nazi Party in 1933 together with Carl Schmitt. And the article I look at, Kirche oder Partei, the Catholicismus im Neuen Reich, Church or Party Catholicism in the New Reich, seeks to define religion or Catholicism in this new period. And he writes that the ontological authenticity and inner greatness of the German Revolution are proven by the fact that it posed the question of church and state in all its depths. So it seeks the importance of the Nazi Revolution, according to Barion, is that it seeks to defend the end and nature or purpose of law, and it does that in a strange way, in a way that is similar to Radbruch's definition of law as evaluation and religion as something that is beyond evaluation. Because according to Baryon, the church should not be a party. So he's thinking of the Centrum party, which he saw as a potential threat to Hitler, even if Centrum in the end supported Hitler. But Baryon was so reactionary that he still saw the German Catholic Party Centrum as a threat that politicized Catholicism, and the church should be fully apolitical, but it should not, as for Radbruch, entail a critique of politics or law. It should simply be a way to shift our perspective towards what Baryon saw as our eternal end, namely God. And the state should not seek to defend these relative values. The state should not be a sphere of relative values. It should establish homogeneity and order, and it should secure peace. So Schmidt wrote in 1929 that democracy requires first homogeneity, and second, if the need arises, elimination or eradication of heterogeneity. So the total state was an instrument for such homogeneity. And this is, of course, the total opposite to what Radbruch was defending. And so the article puts Radbruch against Baryon and Baryon against Radbruch. And in one sense, of course, the conflict is very easy to understand and not surprising at all. I mean, Radbruch was, all that he fought for was destroyed by the Nazis. But there is a peculiar similarity in the sense that both of them both Baryon and Radbruch sought a perspective beyond law. And for Radbruch, that was a perspective that sought to move beyond judgment and hence beyond what he called value, and therefore a perspective that relativized all value, even the values of society, nation, state, politics, law, and so on. Whereas for Baryon, religion was in a way an attempt to absolutize value and defend a state and a politics of absolute values and social homogeneity rather than legal relativism and social heterogeneity. And I think that is a very fascinating debate and a very important one. Thank you.
Thank you, Morten. And then finally, I'll give the word over to Matilda and Simon as well.
Thank you very much. So I'll start by sharing our PowerPoint. So thank you all for joining us, and thank you for hosting us. So we have co-authored, me and Simon, this article, Fulfilling the Mission, the Christian Mission Through Law. And our contribution to this special issue really takes the issue of the end of law to the practical, sort of down-to-earth, nitty-gritty, everyday situation. And as you have already realized as well, we go backwards in time because me and Simon, we look at archival material from Congo, 1881 to 1908. We look at the sort of practical theological and legal work done by Swedish missionaries from the Christian mission, the Mission Covenant Church of Sweden, Svenska Missionsförbundet's mission to Congo during this time. So our main contribution, if you like, is to look at the fulfillment of law at the end of time, so taking the eschatological urgency of this era and time and the fulfillment of the Christian mission through actually going out in the world, and not only making sure that souls are saved in the Christian missionary sense, but also to build a state, because a state, as the missionary saw it, was indeed necessary and not there at this time, but necessary for the fulfillment of the Christian mission. And we also, in doing so in our article, we point to law being and doing different things. So there are the divine law and there is the earthly law. So divine jurisprudence and earthly jurisprudence. And the earthly jurisprudence is not, as during the Weimar Republic, is not a state, because at this time, at this place, there is no state in place. So how can you do your theological work? How can you perform the missionary mission if there is no state to respond to, there is no state law to relate to? Well, as we show in this article, and which is also one of the core findings, is that the missionaries took on roles as legal actors. And we will show you, and Simon will take you further in a short bit into how this really happened, because of course it's one thing to have a more or less neat theological position on law, but a completely different thing, as the missionaries found out very quickly, to turn that into practice once on the ground. So here is one of the an image from the archive that we work with, and here are some of the key points that we draw out in the article. So the missionaries, they came as Christian actors. That was their main goal, but accidentally, or as part of that fulfillment, they also became legal actors. They worked towards normativity. They operated, and that meant introducing individualization and legal subjecthood as individualized. Now, this was not a practice in the Bakongo society where they arrived, as individualization, or the individual subject, as someone who has the capacity to take on responsibility, is a necessity for the Christian mission or for redemption. That became a core issue of the theological mission, but also accidentally, as it were, became part of the creation of the individual legal subject, also as a criminal individual legal subject. They operated within structures of already existing norms. So arriving in 1881, there was no lack of norms and orders, society, culture. But those did not have a Western flavor, or the kind of concepts that were familiar from a Western perspective of the missionaries. But they did have normative patterns, and they had, importantly, they had a very strong importance for how to perform everyday life and society, and thus how the missionaries could carry out their work. And so the missionaries came to practice, and as Simon will show in a short while, they came to actually perform court hearings, where they, as missionaries in the missionary stations, they decided on cases where pre-colonial Bakongo normative arguments and orders were used by the missionaries to decide cases between their parishioners and individuals from the surroundings. But they also acted simultaneously as officier de civil d'état, so civil servants or representative of the civil state. And that was mainly because there was not personnel around from this very, very thin early colonial state, and the colonial state being the Congo Free State, so the Leopold state, in its early iterations. And the Swedes, they used and implemented some of that jurisdictions and represented it as well. And then to some degree, they also exercised the divine power. And together, they were protected by the military power of the Congo Free State, meaning that they were part of and partial of that state structure. So they acted in kind of a state. So over to Simon.
Yeah, well, this situation became. I mean, the missionaries, they had their theological understanding of the word and how things should work, but on the ground in Congo, they realized that things were quite different than what they expected. So while the leadership in Sweden, they stemmed from the revivalist movement, and they criticized that the state intervened in the church affair and argued that we want the separation between further to separate church jurisdiction from state jurisdiction. And arriving in Congo, they were confronted with a system, a political and normative system that was very different from what they had experienced before. And in one way or another, missionaries as our missionaries arriving in the pre-colonial Africa, confronted this in some way and dealt with this quite differently. Komarov and Komarov show us an example from Protestant missionaries among the Tswana, where they tried to integrate Presbyterianism with the Tswana traditional religion, and asked their members of their congregation to participate in the rain-making ceremonies and so on. But where the converts reading the Bible started to see this as pagan and refused to do so. But the missionaries, the Swedish missionaries in Congo, they made another decision, and that was that there is no way that pre-colonial normative order, that pre-colonial administration of justice could work together with the Christian life and a Christian normative system. And they hoped that this colonial state would take this role so that eventually church and state could be separated. But in the meantime, they acted in many ways as Matilda has told you, as legal actors. And should we go on to the slide with the notebook, Matilda?
Yeah.
And this, so this is actually, I would say it's kind of in one way, it's I mean, it's a natural finding to find in relation to their ideology and what they wanted to do. But in one way, this is very peculiar because we find Swedish missionaries arranging what they called trials or rättegångar in Swedish. And they understood this as, I mean, they had a very kind of common sense explanation of it, being that they wanted to replace the authority of local chiefs. And they wanted to change local normative system. And they wanted to dismiss certain type of evidence that was existence in the pre-colonial society. For example, the oracles as use of proof and other things. And in particular, they understood the pre-colonial law to be too entangled with local kinship structure and matrilineal kinship structure. And as Matilda also mentioned before, they understood the the justice system to be too little based on individuality and individual sense of guilt and remorse and so on. And the missionary describing the pre-colonial justice system, they said that the chief would defend all his subjects and pay their fines. And we don't have this sense of individuality in the administration of justice. So we found this book in this mission archives, dated to 1904, which is written by Börjesson, who is the man to our left in the front of the picture, who took notes from these trials, but something that might be maybe more described as mediations. So he described some 20 cases or so, which of very, very distinct, very, very different cases. And they often take the form of mediation between two kinship groups over conflict over marriage, and there are even one case where several people of one kinship group have been killed by another in an incident, and the missionaries try to mediate and to make people to come to some type of verdict. And I think a prominent point that we're trying to make through these examples is that this created a very peculiar form of distribution of justice, where they explicitly reference both colonial legislation in some of their, what they call their verdicts. They reference pre-colonial law, pre-colonial normative systems, and they also reference like common sense and Christian beliefs, and they did this with kind of a mixed authority as being part of the colonial state, but also independently working for a state, an imagined state. Do you want me to say anything else, Matilda, or do you want to round this up?
So I think that we should round it up and open up for question, but leaving this sort of the main, the wrapping up of our article and our contribution, bringing about the difficulty of going from implementing a theological position, running into realities, and ending up doing law in new ways and performing both legal and theological positions that were perhaps not what was in the books or what was planned. So thank you.
Thank you, Matilda and Simon and Tormod and Morten. So I will take a question from the Q&A in just a minute, but just to offer one own reflection. So a theme that I really see running through the articles, but also emerging from the discussion here among you guys is the question in a way of how to deal with, can we say, uniformity and heterogeneity, or plurality and unity when it comes to conceptualizing law and justice as well. And you are calling for, to some extent, for a richer set of conceptual tools or languages or vocabularies when it comes to calling out justice and formulating a critique of worldly laws and its limits, if we might say. But your article, Morten, also shows Baryon struggling with this fragmentation of heterogeneity and finding that sort of a challenge to be tackled, whereas the Swedish missioners clearly, while coming from a situation of homogeneity and surely recognizing the challenge, also come to see this plurality in terms of legal plurality as an opportunity. And I imagine that in a way, these different ways of approaching or relating to fragmentation or plurality depends on theological perspectives, including on law itself. And with that said, I want to go back to the question of in way of picking up on conceptual tools, because the question we have in the Q&A from Judith Hahn is related to this in a way, and it's directed primarily to Tormod. It's a question about your reference to mercy as a correction or maybe an addition to justice. This relationship is somewhat critical, particularly when it comes to the law, as mercy always undermines justice to some extent. So what would you say? How can one navigate the inevitable tension between the two, between mercy and justice, without mercy undermining the law, particularly with regard to the criterion equality of the law, which is also a matter of justice?
Yeah, thank you very much, Pamela. I think both your comments now and this excellent question from Judith, thank you for that. Very important and goes to the core of what I was trying to say, but also what you were referencing, that we all engage with in some way. Because I think, I mean, directly to Judith Hahn, I think there is a conflict, of course, between mercy and justice if we think about them in this frame of what Heller would call formal concept of justice, and which can go by other names. There is definitely a conflict between these, because there's a sort of requirement that we there's always a call for justice, and justice most often means that you should give me what is due to me, or you should punish that person because they have done the wrong thing, etc. But I think that there's at least three different ways I think mercy relates to justice beyond just being in conflict with it. And one is that mercy, of course, as is said here in the question, in one way undermines justice. But I also think that mercy saves justice in a way. And it saves justice in the way that it saves justice from itself. Because justice, as Morten and I also discussed in our book to some length, is that justice exacted can also lead to injustice. So I mean, we have this excellent quote from Hamlet saying that if you use every man after his desert, and who should escape whipping? So it's a sort of, I mean, if we actually give everyone what they are due, then we destroy the world. Like literally, we destroy the world. And I think this is also then why I think it's very important to relate to this more theological or religious understanding, prophetic understanding, or philosophical understanding of justice as being something higher. Both higher, I mean, for Aristotle, it's a sort of, it surrounds this smaller concept of formal justice, but it's also sort of higher justice in that it saves all of us. And I think that's part of the Christian message, for example. That is, I mean, we are all sinners, but Christ has saved us through his sacrifice. So I think, and that also means that this justice in a more restricted sense is lesser and smaller. I mean, you can say it in different ways. And I think that, just shortly, that it goes towards this aspect that you were mentioning, Pamela, because both what Teubner was mentioning and what you were talking about now, Matilda and Simon and Morten, in these different historical situations, is that whenever a certain conception of justice grows too hegemonic, then it sort of implodes on itself, or it becomes unstable, because there's always a need for another type of justice beyond it, and that's part of the whole story, I think. So yeah, thank you. I'll stop there.
I will take another question from the Q&A by our colleague and the director of the center at Emory, John Witte, who first of all wanted to thank everyone for the excellent papers and me for bringing you together. And I'm just grateful to be here to facilitate this. But the question is to the group as such is, what's the place of church law and other religious legal systems in the various theories of justice, and as a distinct repository of teaching, mercy, discipline, charity, social organization, and more. So this also goes back to my initial comments. So thinking more about what are these richer sources, and to what extent can we also think of church law in this context. So who would like to start?
I can say something. Yeah. Of course, Baryon was a canonist, so of course he wrote a lot about church law, and for him, church law should not be, I mean, it has to be based on freedom. So you have to accept church law. It cannot be imposed on someone who does not accept church law, which is fascinating because since he defended Hitler, he defended the Third Reich, but at the same time had this almost liberal understanding of the church as a society that, according to him, should not be political. He used the word political in the sense of Carl Schmitt's, his friend Carl Schmitt's sense, that having an enemy. So politics is the differentiation between friends and enemy, and of course the church is an apolitical, or what you call supra-political community. So the law of the church, according to him, is this law of freedom, but it's based on commands. Radbruch was, on the other hand, extremely fascinated by, he was not a Catholic, but he was fascinated by Catholic canon law because he saw it as a proof that we could have a global law, so a law that is not bound to the nation state. And he seemed at the end of his life to hope for an order beyond the nation state, because the nation state and the different legal systems point, in a sense, to what he was afraid of, namely that anarchy would beat law. So he was fascinated by the fact that there existed a global law in the Catholic Church. And also in some of his articles, he discusses how during the medieval period and the early modern period, how, well, criminals and so on, or other people who were hunted by the lords could seek refuge as asylum in the church. So for him, that's fascinating there, because Radbruch, as a socialist, a social democrat, a liberal, he in a sense wanted the church to have political effectivity against the state. So in that sense, he had a rather, conservative vision of the church as a church that could chastise the world, that had a right to chastise the world, and in a sense threaten, perhaps not threaten, but at least command the state to listen to the call for justice, for instance. Whereas Baryon, the defender of the Nazi revolution, in a sense had a more liberal conception of the church as something that should not taunt the state. It should simply point us to God, and it does that through canon law, because the canon law shows what God is.
Do you want to add something as well, Matilda and Simon?
Just perhaps something very briefly. So the Congo Free State, during the Berlin Conference in 1885, when the Free State sort of was allowed to take its initial form, one of the conditions for that was that Leopold would allow both Catholic and Protestant missionaries to enter into the territories. And from the beginning, there was, or all the way, well, for a long time, that was also the case. But when we look into the official bulletin of the Congo Free State, so the state commenting on what the Catholic missions and the Protestant missions do, there is this very, very clear slippage from allowing both denominations or churches to be there to having a preference for the Catholic Church. And why is that? Well, the explanation that we can find in the commentaries is that the Lutherans, they entrenched on the sovereign power of the Congo Free State, whereas the Catholics had a much more they refrained from exercising the kind of jurisdiction that the state would otherwise have. And that goes back, of course, then to the Catholic Church being a global church and having global law in a sense, if we like, in the very practical sense. But that's how the Congo Free State saw the Protestants as a threat eventually, and the Catholics as a possibility, as a collaborator with the state.
Can I suggest something brief also?
Yeah.
I mean, the context for our missionaries, I mean, it's very different from the Catholic. They were independent, revivalist, newly found church. And this ties to what Matilda said. They had this idea that church law, like this, the constitution of the church, needed to be very thin and needed to be anchored in the Bible, while they could exercise other powers and have more stricter laws in the state. So, for example, that was a conflict over the drinking of palm wine, for example, where the missionaries wanted to prohibit palm wine in the church constitution in Congo. And the director in Sweden said, you cannot do that because that is not according to the Bible. And you're making sinners. You're creating sinners when you make sins that are things that are not sin. And then there was this conflict where the missionaries wanted to make the church law more and more extensive. And they said, why can't we, just like the first apostles, make our own laws? While the church in Sweden said, no, you can absolutely not do that because it has to be according to the Bible, because you are not John and Paul. So, yeah.
So thank you very much. I can see that there are further questions in the Q&A. I'm really grateful for the fact that this presentation, this webinar has spurred these questions. And unfortunately, our time is up. So I also encourage you to really just reach out to the authors. I'm sure they will be happy to enter into conversations with you around the topics of the papers, the presentations, but also more generally on the issues that you are wanting to bring up and discuss. So on my part, I just want to thank all of the speakers, but also all of you who joined our webinar. We had a really great group together, and I'm really grateful also for the ones who wanted to pose questions and also add comments to our conversation around the theme of the nature and end of law. And with this, I want to give over to Whitney.
Well, thank you, Pamela, and thank you so much to everyone who joined us today. I'll just echo on behalf of the center our gratitude for your time and engagement, and thanks again to our wonderful moderator and panelists for sharing with us your papers and your thoughts. We're delighted to host this conversation and look forward to posting it online on our YouTube channel in the coming weeks. So please, we'll have that link ready. Please check it out there and share with those you think might be interested. But just thank you again for joining us, and thanks again to everyone who participated.